Criminal trial, right to represent yourself. Does it exist? Well, that takes us to this week's case. Involves a real woman, Angelique Bankston. Angelique was accused in federal court of 23 counts of fraud. Basically, she had set up a scheme whereby she would steal somebody's identity, open bank accounts, apply for credit cards, manipulate money in such a way that she would steal from the person whose identity she had stolen. Well, she was charged with these 23 accounts. And just before the trial began, she said, I want to represent myself. I don't like the attorneys that have been trying to represent me. I want to represent myself. And the judge said, are you sure of this? She said, yes, I am. And she represented herself. And guess what? No surprise, she lost. She was found guilty on all counts. Well, she appealed the case, went up to the Sixth Circuit Court of Appeals. And there the question arose, did she knowingly and volitionally waive her right to counsel? Now, under the Sixth Amendment of the U.S. Constitution, everybody has a right to an attorney. But the Supreme Court has also said in reviewing that everyone has a right to represent themselves. The question is, however, before somebody begins representing themselves, do they really understand what's going on and the consequences of what can occur? Are they making a knowing waiver of counsel? Well, that puts the trial judge in a very difficult situation because the trial judge realizes how important the criminal proceedings are and the consequences that can arise, and realize that a lot of lay people really don't have a clue about what's going on in a courtroom. Yet, the judge has to allow someone to exercise their own free will. So in this instance, the Sixth Circuit Court of Appeals took a hard look at the transcript of this criminal proceedings and looked at the various questions that the judge asked this woman before he allowed her to represent herself. Among the questions he asked her were such things as, what's the highest grade of school that you've completed? Well, you went to college. While in college, did you take any criminal procedure courses? Did you take any criminal law courses? Have you ever represented yourself in the criminal proceedings before? Do you know the nature of the various counts that have been brought against you, each and every one of these 23 accounts? Do you know what kind of defenses you're going to lodge? Do you know what you're going to use in order to establish those defenses? And she went through an explanation of all of this, and at the end of the day, she said, I want to represent myself. Judge came away and said, well, based upon this information, I'm going to let you exercise your own free will, and I find that you have knowingly, with understanding, waived your right to counsel. Therefore, you can represent yourself. And she did so. And the Sixth Circuit Court of Appeals said that the conduct of the judge was correct, that there was a sufficient questioning of her, and that she had demonstrated at every turn of the corner that she knew what she was doing, and she went into this with both eyes wide open. Okay, we bring you this case, we bring cases every week so you understand how the law works. I'm David Allen.